Hello, everyone. Professor Cornish here. Welcome to our presentation today on federal crack cocaine legislation. Now, some of you might be wondering, why is she doing a presentation on crack? It's not in the news. It's not a problem right now. Why? The reason why it's really twofold. One, discussing federal crack cocaine legislation really illustrates what happened during the war on drugs, especially in the 1980s and the 1990s. And really, this is an ongoing issue. Efforts to fix the problems that were created by the legislation, they're still ongoing. I originally recorded this presentation in 2001. And unfortunately, the efforts then did not pan out. And current efforts to fix the adverse issues created by crack cocaine legislation, they are now still ongoing. So this is a current issue. So let's go ahead and get started. Now, first, just a little information about cocaine. Now, it is derived from the cocoa plant, and it's a stimulant. Stimulants, they enhance mood, increase alertness, they relieve fatigue. Now, cocaine, when it initially was developed, it was widely used in the southern region of the United States. And it was used in various medicines, both prescription and over the counter. And also, it was used in soft drinks. That's where Coca-Cola comes from. Coca-Cola originally had cocaine in it. It does not anymore and hasn't for a long time. Now, in the 1890s, in the South, amongst whites, there started to be a concern about the drug being used by blacks. Now, 1890s and a little on, after the Civil War, we still had major racism issues during that time. Blacks were still seen as inferior and not equal to whites, and that they shouldn't have rights. So it was still a pretty bad time. The Civil War did not fix things. Now, whites became fearful that if blacks were using cocaine, they would forget their place in society. They might even become violent towards whites. Now, due to public outcry, fear as well as racial connotations, basically racism and prejudice, the Harrison Act, which the act is the first criminalization of a drug in the United States, was passed in 1914, and it legalized the unauthorized distribution and usage of powder cocaine. So the Harrison Act is our first criminalization of a drug. Cocaine, first drug that was criminalized. Now, there's two types of cocaine that are widely used: powder cocaine and crack. Now, powder cocaine, it's fully known as cocaine hydrochloride, and it's known as either coke or powder cocaine. In this presentation, I'm just going to say powder. Now, obviously in the presentation, you can see a little bit of how it's created. Now, powder was pretty popular in the 1960s amongst Hollywood elites, and it became really mainstream as a recreational drug in the 1970s, and it even stayed that way into the 1980s. If you've ever seen the first Crocodile Dundee, there's a scene in the movie where they're at a party, and Mick Dundee goes into the kitchen and he sees this man right there snorting cocaine. There's also a scene in Die Hard where there's one of the characters in an office in a business building snorting cocaine. So it was pretty mainstream. Even though it wasn't legal, it was pretty mainstream. Now, the price per gram of powder ranges from $75 to $100. So you can see it's pretty expensive. And because of that, it was predominantly used by upper and middle class whites. Now, crack, it is a converted form of powder that goes through more of a cooking process. Now, crack originated in 1981 in Los Angeles. Now, crack became more desirable with many people because of the price. Crack was distributed in smaller doses, and therefore the price was a lot lower, $3 to $20 per vial, which is a lot more affordable than $75 to $100. And also the little vials that it comes in, which normally that's what happened. You have a little vial that's got some rocks of crack in it. Pretty easy to carry. That's kind of why it was so desirable, the price and it being easier to carry. Now, powder and crack are pharmaceutically identical, and they have virtually the same intoxicant effects. Now, really, the only difference between the two comes from the ingestion method. Now, powder, its common ingestion method is inhalation, being snorted. Now, its intoxicant effects, it takes roughly 5 to 15 minutes, and they last for about up to 2 hours. Now, crack, its most common ingestion method is smoking. Therefore, it gets into the system quicker. So its intoxicant effects felt within 5 minutes. And in a lot of cases, it was sooner. Now, initially, you got a pretty potent rush that lasts for a few seconds, and then it's replaced by euphoria that lasts for several minutes, average of about 15. So powder takes longer to feel the effects for it to get into the bloodstream and start circling around, but then the effects last longer. Crack, the effects are felt quicker. They're initially more potent. However, they don't last as long. So users of crack, quicker, more potent highs, shorter lasting euphoric effects. Now, crack really, because of its price as well as how easy it is to conceal, it was predominantly used by Blacks, Hispanics, your more non-affluent people, like maybe lower to middle class, especially those residing in urban areas. Now, remember, crack first came on the scene in 1981. So between 1983 and 1985, the usage of crack by Hispanics and Blacks doubled. But the usage also increased with whites as well, and other races. It took some time for crack to start spreading out. And as it spread, it became popular, cheap, easy to carry. Now, crack in popularity reached its peak at around 1989, and rates started declining thereafter. Now, in 2000, it remained at about approximately 60 to 75% of the peak levels. Now, here's another difference between powder and crack. Powder, because it comes in larger quantities, it was sold in really great privacy. And especially since you had the more affluent using it, they didn't want to get caught with it, especially because it wasn't as easy to conceal. So it was done in more privacy. And because of that, it made detection by law enforcement a lot more difficult. Law enforcement, with it not being done on the street, it was a lot harder to arrest dealers, to arrest buyers during a sale. Now, only 29% of powder was sold at the street level. And 37% of all federal powder trafficking offenses are linked to neighborhoods and cities. So only 29% are at the street level. Street level, basically, your corner deals out in the open. Now, mainly cocaine, it's trafficked by cartels. Now, 66% of all federal crack trafficking offenses occurred at the street level. So your corner deals. Now, crack, because it comes in smaller quantities, more easily concealed, lower cost, it's sold predominantly at the street level, out in the open in high volume markets. And really, it's predominantly sold in neighborhoods where you've got high concentrations of criminal activity and gang activity. Reason being is if you would sell it in a different neighborhood, you'd get the cops called on you in 2 seconds. Where if you're selling it in the neighborhood that's got criminal and gang activity, it's just going to blend in with everything. Now, there are a lot of myths surrounding crack that did cause a lot of hysteria that ended up coming into play when we start going into the actual federal crack cocaine legislation. Now, one myth was that crack is 500 times more addictive than powder. They're virtually pharmaceutically identical. The only difference is crack, you've got more processing than powder. And they've got virtually the same toxin effects. The difference is because of the ingestion process method. That's it. Another myth, crack's associated with extremely violent behavior. The reason why there was a lot of violence when crack first came on the scene. This happened in Los Angeles. It happened in every major US city as crack spread nationwide. You had the street gangs that were starting to get a hold of crack and selling it. They were fighting over drug territory. They were fighting over turf. Now, this decreased in the early 1990s because the street gangs, they got their turf established. There wasn't as much fighting. This gang respected this gang's turf and vice versa. And also, there was a decrease in the cost of crack, which made it less profitable for gangs to sell. If you've got a drug that's losing profitability, a gang there's a large money element with a gang. They're not going to want to sell that drug anymore. They're going to want to go to the next popular thing that's going to make profits. Now, the profitability of crack also decreased because the individuals that were using crack, they started aging, maturing. They stopped using it. And also, you had more accurate information about the drug's effects. So you had, in addition to that, more people that weren't using it. It's like, hey, this is kind of dangerous. It's not a fun high like I thought it was. I just don't want to use it. So you had all these things factored in, and that'll happen with a lot of drugs. When they first come on the scene, oh, this is just a great, great thing. And then when they've been out for a while, you'll either have people that'll get tired of using it, or they'll go to the next best thing. The newest thing on the market. Now that we've discussed really what crack is and some of the myths, let's go into how the United States government responded to crack. And we do need to give a little back information on this. Now, in 1984, the Comprehensive Crime Control Act established the United States Sentencing Commission. Now, This was enacted to achieve, really at the federal level, uniform sentencing guidelines. And the Comprehensive Crime Control Act made the guidelines set forth by the Sentencing Commission mandatory in all federal district courts. So federal judges, they could not deviate from the sentencing guidelines in determining what sentence was appropriate. Now, so basically, these guidelines are what's called determinate sentencing, meaning fixed. The judge has no power of choice in determining the sentence. The statute says you commit this offense, you get this punishment, period. The judge has no say in the punishment. Now, the reason why determinate sentencing became used was to fix sentencing disparities that the use of indeterminate sentencing, those where the judge has a choice, determinate sentencing was meant to fix that. Now, a sentencing disparity is really the divergence in the lengths and types of sentences imposed for the same or comparable crime when no reasonable justification exists. So then you have to think of, was there some bias on the part of the judge? Did he just not like this person because of their race, their ethnicity, their religion, their gender? Was there a difference in where the crime took place, or maybe where the court happened to be? So determinate sentencing was made to fix that. But as we'll learn as we go through the presentation, determinate sentencing ended up creating a new sentencing disparity when it came to crack. Now, in 1986, Congress enacted the AntiDrug Abuse Act, ADAA. Now, this was in response to public fear, media coverage, and inaccurate perception of the addictiveness and danger of crack based on research and expert testimony. Which there was, when crack first came out, there was a lot of bad research on it. A lot of guessing stuff that later on it was proven it wasn't accurate. And then there was fear of, oh my gosh, crack's creating all this violence. And on the news, they had, they had depictions of babies being born addicted to crack, and they had all these depictions of these people using crack. I mean, I was 10 at the time this act was enacted. And I remember how bad the news was during this time. It's no wonder the public was so fearful of crack. Because watching the news, it actually got kind of scary. Now, the ADAA established a 100-to-1 sentencing ratio. So the sentence for 1 gram of crack equal to the sentence of 100 grams of powder. So 1 little gram of crack, you were getting the same sentence as somebody who had 100 grams of powder. So crack, personal recreational use, 100 grams of powder cocaine, that's trafficking. No one's going to use 100 grams of powder for recreational use. So someone, personal recreational use of crack, simple possession, was getting the same sentence as a cocaine trafficker. Now, the 100-to-1 sentencing ratio was justified at this time because, like I said, there was so much fear, so much misinformation. It was felt that crack was so much more addictive than powder. It caused people to be violent, and hey, it's low cost, makes it really, really attractive. And also there was a lot of concern about its use amongst juveniles and pregnant women. Now, the act was felt to be the only way to resolve the turmoil in what's called socially disorganized neighborhoods where you've got a lot of crime going on, which some of these neighborhoods in the early to mid 90s, you did have a lot of gang turf wars. And some of these neighborhoods in the major cities, they were pretty much war zones. So it was felt that, hey, the only way we can resolve what's going on in these neighborhoods is if we eliminate what's causing it. And at that time, it thought it was crack. Now, the Sentencing Commission adhered to the 100-to-1 ratio in the ADAA when it developed the federal crack cocaine sentencing. Now crack related offenses were deemed such a significant threat to society and caused such a significant harm to society that it was felt offenders that were committing crack related offenses needed to receive harsher punishments that were proportional to the social harm they caused. So you're creating greater social harm, so we're going to punish you a lot harder. And that's going with some of the purposes of punishment is retribution, which is societal revenge, as well as incapacitation. Removing you from society for a period of time so you're not going to be able to commit crimes. It was felt that because you caused such great societal harm, you needed to be punished by society more severely and removed from society longer so you can't commit crimes that'll harm it. Now, also, there was another purpose of punishment is deterrence. We're going to make the punishment so severe, you're not going to want to do it. Because crap, I don't want to do that. I don't want to go to jail that long. I don't want to get that sentence. So it was felt that, hey, if we make these sentences severe, it's going to deter the general public from using crack, as well as the people who are using it, they're going to stop using it. Because, whoa, I don't want to be in prison that long. Now, does deterrence actually work? Not really. You're relying on the person to actually think before they act and actually be fearful of the punishment. And now, really, although the ADAA, Congress thought they were doing the right thing, it did end up having massive adverse effects. Now, 2009, 79% of all federal crack legislation convictions were Black, while only 10% were white or Hispanic. Only 40% of the disparity of the high incarceration of Blacks can be explained by greater involvement in criminal activity. So if anyone argues that, oh, well, that's just because Blacks engage in more crime. Actually, no. They only comprise of 13 to 14% on average of the US population, and the same percentage of drug users. Now, in 2000, Blacks comprised 35% of drug arrests, 95% of convictions, 74% of incarcerations. Now, the ADAA, it wasn't enacted to discriminate against Blacks, Hispanics, or the poor, but it did utilize these disadvantaged groups to achieve political electoral ends for the benefit of appearing tough on crime. Now, when the act was passed, we were in the middle of Get Tough on Crime. Get Tough on the Crime and the war on drugs happened during the same period. And if you were seen as weak on crime, you were voted out. Even President Biden, when he was a congressman, voted on the ADAA. Now, he later said he made a mistake, and the rest of the congressmen that voted on it made a mistake. But at the time, it didn't matter if you were Republican or Democrat. If you were not seen tough on crime, you were losing your job next election. Now, going into some court cases, because pretty early, because you were having a lot of Blacks, Hispanics, and the poor getting arrested for crack offenses and being incarcerated, you had a lot of arguments towards, hey, this act is racially biased. So just to give a little bit of case law foundation, Washington and Feeney, both Supreme Court cases, stated a law must be ultimately traced to a discriminatory purpose or create a disproportionately adverse effect upon a racial minority is only in violation of the 14th Amendment's Equal Protection Clause if the law's impact can be traced to a discriminatory purpose on the part of the legislature. So basically what that is saying is you've got to prove the legislature's intent was to discriminate with the act. Now, it's quite a few court cases, and all of these circuit court and district court level stated the ADAA and the sentencing guidelines didn't breach the 14th Amendment's Equal Protection Clause because the act was not discriminatory on its face, which is actually true. Now, Pickett and other cases stated the sentencing guidelines of crack-related offenses, and you can see Pickett in 1991 case, so we are still very much in Get Tough on Crime. It was felt that sentencing guidelines of crack-related offenses due to being greater in severity than powder did not constitute cruel and unusual punishment under the 8th Amendment. The reason why it was felt that crack was such a significant societal harm, more so than powder, that the punishments had to be more severe. Now, like I said earlier, powder, although it was kind of mainstream, it was still used in secret. It wasn't used out in the open. So you've kind of got the difference between powder and crack in that regard. Powder bought and sold in secret, crack, you've got the street corners. So that is some of the reason why, the arrests are disproportionate. If it's out in the open, it's easier for law enforcement to catch it, versus if it's done in secret, it takes a lot more intelligence. Meaning intelligence that, hey, this is going down. Now, the next case we're going to talk about, which is the Supreme Court case, Apprendi, it stated the federal sentencing guidelines violated the 6th Amendment. So this is 2000 case. 2000, we're actually out of Get Tough on Crime. Get Tough on Crime really had its wind down mid-90s. So 2000, we're out of Get Tough on Crime. Although fixing everything that was created from Get Tough on Crime, and there was a lot during that period that I'm not going to go into this presentation because it's not applicable, but we're still fixing things from Get Tough on Crime. While things were quick to be instituted in Get Tough on Crime and the war on drugs, they weren't so quick to be done away with, unfortunately. Now, the Sixth Amendment in Apprendi, Supreme Court of the United States, or SCOTUS, felt the Sixth Amendment was violated as a result of mandatory minimums supported the guidelines preventing juries when acting as decision makers regarding the appropriateness of a sentence from making determinations regarding all the facts, mainly aggravating circumstances, things that make the crime worse, which would affect sentencing length. So basically, Apprendi, what they're saying is, hey, you've got to be able to look at aggravating circumstances. They have to factor in. Now, another big case, another SCOTUS case, Booker, 2005 case. It overturned the Sentencing Reform Act by stating that sentencing guidelines instated by the Sentencing Commission were advisory only. Now, you can see that Booker, you've got potential issues Booker could have created as well. Because if it's advisory only, you could have judges make decisions on prejudice and bias again. Now, after the Booker decision, federal district courts, specifically districts and judges in disagreement with the 100-to-1 ratio between crack and powder cocaine, began utilizing their own ratio to determine the minimum sentences for crack offenses. So you had judges, when the reins were taken off, were like, you know what? This 100-to-1 sentencing ratio is garbage. I haven't liked using it. I haven't felt it was fair. I'm not going to use it anymore. Now, Fisher, and this case falls out of New York, 2005. It stated there was no rational basis for the 100-to-1 ratio. And it stated that, hey, research conducted after the ADAA showed that crack and powder, pharmaceutically very similar. It's just a matter of the end processes and the addictiveness and the high from it, virtually the same. They were like, there's no rational reason for this sentencing disparity anymore. It's been proven. Now, in Faux in Europe, as well as other cases, they rejected the use of ratios less than 100-to-1 established by the ADA by the federal courts. So this kind of reversed it. They were saying, hey, the ratio was put in for a reason. We shouldn't be going against it. Kimbrough, 2007 case. Booker's determination that the sentencing guidelines were only advisory, it was actually applied to crack cocaine. So this is finally the first formal ruling, and it's by SCOTUS, stating that, hey, Booker applies to crack cocaine offenses as well. The punishments for them. Spears, which another SCOTUS case, 2009, federal district court judges could reject the established 100-to-1 ratio and vary categorically from it based on a disagreement with the policy, as long as they didn't go above it. So they could go below it all they wanted, but as long as they didn't go above that 100-to-1. So you see, we're starting to have SCOTUS is starting to correct things. But really, there's only so much that SCOTUS could do, and we'll keep going through it, and you can actually see. Now, here's what should have been the big fix: the Fair Sentencing Act, and it was 2010. Now, it was passed and signed into law to resolve the new sentencing disparity between crack offenses. That disparity that crack and that 100-to-1 ratio created between crack and powder cocaine, as well as alleviate the racial one. Because like I said, because you had crack being trafficked, sold in neighborhoods where you did have a lot of minorities living in, and it was done in a manner that was easily detectable by law enforcement, you had a lot of minorities that were getting arrested. Now, also, because, like when the ADAA first came out, since crack was deemed enemy number one, you did have on federal law enforcement, state and local law enforcement had this as well, a lot of, you guys need to make sure you're going after crack. It's a bad thing. Get those people. That's what they were being told. So you had law enforcement getting a lot of pressure. Get the crack dealers, get the crack users off the streets. Now, were there law enforcement that agreed with it? Because, oh, well, I'm prejudiced, so hey, it's going with my feelings. Yes. Did you have a law enforcement there going, this isn't right? Yes, you did. Now, the Fair Sentencing Act established an 18-to-1 ratio. So if you had 1 gram of crack, you would get the same sentence as somebody who had 18 grams of powder. Now, the reason why the ratio was not put to 1-to-1 was to get this thing through Congress. That was the only way they could do it. Because you had a lot of congressmen didn't agree with it, weren't going to vote on it if it was 1-to-1. And I think that's because you still had some congressmen that still had that get tough on crime mentality, and they hadn't shifted, as well as they were still believing that, oh, crack is way, way worse than powdered cocaine. So I think that was some of it, as well as I think that it's kind of used to, sometimes when you've got Congress is passing acts, you get a bunch of things that are all jammed in together. So I think it was kind of a quid pro quo as well. Well, hey, make it to 18-to-1 and I'll vote yes on this and this. I think there was a lot of dealing. But yeah, that was the only way they can get it passed, was the 18-to-1 ratio. Now, first-time federal offenders convicted of simple possession, regardless of the amount possessed, were now exempted from the mandatory minimum sentences and could only receive a max sentence of incarceration of 1 year. So it did recognize that, hey, simple possession, we can't be given these horrendous sentences to, especially if it's their first time. Now, the Fair Sentencing Act also raised the threshold in which mandatory minimum was enacted from 5 to 28 grams. Now, here's where some of the issues start coming in. Now, we've already got the one issue with it being the 18-to-1 ratio. The second issue that the FCA did not address was retroactivity, meaning the act being applied to previous cases. The act was not applied to cases, to crack-related offenses committed prior to August 3rd of 2011. Now, here's the thing, though. If they were pipeline cases, meaning they were in the court process, if they were convicted but hadn't been sentenced yet, when the FCA became law, the FCA applied to them. But if your conviction and sentencing was done before the law was enacted, too bad, so sad. It doesn't apply to you. Now, Dorsey v. United States, because there was a little bit of confusion when it came to pipeline cases, because they were like, well, hey, what if the person's was in court when the FCA was enacted, they hadn't been convicted yet? So Dorsey clarified, okay, if a crack-related offense was in the court process, even if conviction hadn't happened yet, it applies. Now, March 2014, Attorney General Holder, which this is under Obama's administration, advised federal prosecutors to not press federal trial judges to impose longer mandatory minimums for certain drug offenses. Now, Holder directed that the FCA be applied retroactively and began preparing for the Department of Justice to expedite the inevitable clemency requests, and urged the Sentencing Commission to vote for retroactive application. So Holder knew that, hey, the FCA, it should have been applied to past cases. So let's go ahead, even though the act wasn't applied that way, and we've got a long road to get that stuff fixed, federal court system, we could start addressing this now. And that's what Holder did. Now, he strongly advocated for a reduction in the sentencing for nonviolent, low-level drug offenders without deep criminal ties and short criminal histories who committed crimes that didn't involve weapons. So he was going, we can't treat all of these offenses exactly the same. We've got to look at the circumstances surrounding each crime. Now, April 2014, the Sentencing Commission voted to lower the baseline offense levels for all federal drug possession offenses, which will shorten the average length of stay by approximately 11 months. July 2014, Sentencing Commission voted to apply the FCA retroactively to all federal drug crimes. So basically, even though Congress was the one that enacted the FCA, the Sentencing Commission was like, we can do our part to start resolving this. Now, as I said at the beginning of the presentation, the issue surrounding federal crack cocaine legislation is still ongoing. So let's look at really what's recently been going on. Now, 2018, this is under the Trump administration. Formerly incarcerated re-enter society, transform safely, Transitioning Every Person Act, First Step Act. Personally, I think they could have came up with a way better name, because that is very hard. But the First Step Act addressed issues with good time rehabilitation, stacking of charges, and mandatory minimums for repeat offenders. So a lot of this act was trying to fix a lot of the issues that came about as of Get Tough on Crime. Like I said earlier, what happened during Get Tough on Crime you had a lot of sentences for crimes that were majorly increased. And even though we know, deterrence, retribution, incapacitation, sole reliance on those does not work, it's taken a long time to reverse everything that was done during Get Tough on Crime. And we've seen this fully now with the war on drugs. So the First Step Act was, okay, we need to kind of further start reversing everything that happened during Get Tough on Crime. Now, the First Step Act did apply the 18-to-1 sentencing ratio for crack-related offenses retroactively to past cases. However, the retroactive application was only triggered if the defendant filed a motion, and applicable only if the sentencing court deemed it to be. It wasn't automatic. The defendants had to file for it, and the sentencing court had the discretion on if it should be applied or not. And really, the First Step Act said that, hey, the judge has the discretion to decide if it should be applied or not. Now, although President Trump signed the First Step Act fully into law, his administration subsequently concluded that possession of a small amount of crack was not a covered offense under the First Step Act. So if you were convicted of simple possession before the Fair Sentencing Act, guess what? Retroactivity that the First Step Act was establishing, it didn't apply to you. So even this act caused additional issues, because not everybody can afford a lawyer to file a motion. And then you've got a judge has to determine if retroactive activity will even apply or not. But then, oh, hey, but if you got nailed for simple possession, tough luck. Now, in Terry, 2021 SCOTUS case, SCOTUS ruled a sentence reduction under the First Step Act is available only if an offender's prior conviction of a crack cocaine offense triggered a mandatory minimum sentence. Now we've got a new law, which some of you might have heard of, because actually it has been in the news for a couple of years. The Eliminating a Quantifiably Unjust Application of Law, or EQUAL Act. September 2001, the U.S. House of Representatives voted this bill through. And they did have bipartisan support. It was actually amazing. Republicans, Democrats, Independents, a lot of support. There was very, very, very few representatives that voted no on this. Now, comparatively to the amount that did. But really what EQUAL is doing, one of its main focuses was ending the sentencing disparity entirely, as well as also applying retroactivity. So this act, it's not only going to fix that sentencing disparity between powder and crack cocaine, it's also going to apply that 1-to-1 sentencing ratio to previous cases. So this is huge. It passed September 2021, it passed the House. Unfortunately, December 2022, it failed to come for a vote in the Senate. And actually that same month in the Senate, it was blocked from being included in federal spending. So it died in the Senate. However, February 2023, you had a lot of these senators that sponsored the original bill, as well as some new ones. They reintroduced it into the Senate. Now, as of the day I am recording this presentation, which I've got the day right here, August 27, 2023, it hasn't been voted on yet. So you might see, depending upon what websites you look at, what you peruse on social media, you might see advertisements for this. But this is ongoing right now. Now, when I know how the Senate has voted on this, I will do an update. No, I will make sure to do an update on what happened. But like I said, this is ongoing. And really, as I stated earlier, President Biden stated that everyone that was in Congress at the time, the ADAA, was voted on and enacted. He said we all made a mistake. We were going off of fear. We were going off of so much misinformation. And he said we should have waited. So that's one of the big points with federal crack cocaine legislation, is it illustrates really the need to have research, to have accurate research, and also the need to, if we realize that we made a mistake, it needs to be easier to correct things. It can't fall on party lines. There can't be all this wheeling and dealing. And that's a lot of correcting the ADAA and everything that happened with it. The sentencing disparity between powder and crack cocaine, the racial disparity that ended up resulting. It should not have been this hard. And hopefully soon, it'll be fixed, I hope. So I hope all of you enjoyed the presentation. If you got any questions, concerns, comments, please feel free to contact me. And if there's anything else you would like me to do a presentation on, just let me know. Thank you for watching and stay safe out there.